In Australia, sadly, a compromise at the highest of levels. So, having produced a set of documents to the Royal Commission, which includes, disturbingly, documents that name in one document 28 people as alleged pedophiles, includes a whole lot of prominent people, and I think to protect the discretion of the Royal Commission, I won't comment on what the Commission thought, except that they thought it was outside the terms of reference of the Royal Commission. Could you explain to me why that is so? I actually want to go to the proposition, Mr. Attorney, that we should include in the terms of reference the institution of the law. And I have documents here which the Royal Commission has seen to justify that case, and in fact every Attorney General, from Attorney General Ruddock till now, has seen some of these documents. They are police documents, and they are very disturbing. It's not so much the secret that's the problem. It's when a group of people, such as the 28 people on this page, keep each other's secrets, that the institution becomes compromised. And on this list, and I won't, there are spectacular examples of that. People involved in hearing court cases, the disgusting culture of some of our institutions. I appeal to you, for you to give consideration to cleaning up this act. I mean, the Royal Commission, the Wood Royal Commission, as you know, Mr. Attorney, was about to explore who the legal fraternity people were that used to attend Costello's, the boy brothel club in Kellett Street, King's Cross. And I've actually got the list here. And a lot of them are still practising. But the judge of the day of the Royal Commission decided it was a no-go zone, and Paddy Bergen, counsel assisting at the time, said, we'll rise for morning tea, and they never went back to it. And I did ask the Commissioner why. He said he'd deny it if ever I mention it. I think it's time to mention it in view of the good work of the Royal Commission. He said, we've decided not to revisit that issue because the public would lose confidence in the judiciary. Because the public would lose confidence in the judiciary. I think it's time, like the churches and our other institutions, who are now... In recent months, I put a proposition to the Royal Commission into the institutional treatment of children, and it's pretty heartbreaking to see what's gone on and what's been denied for the last 50 years now of being exposed as a reality. It's broken a lot of hearts. There's a former Prime Minister on this list, and it is a police document. When the police find it necessary to put a judge under surveillance, I think we've got to a point where we've got a problem. And when that surveillance is dropped because of a lack of cooperation between the AFP and the New South Wales Police, we have a problem. It's like the denial of the priests and the altar boys for 50 years. I have put forward a case which I initiated to remove a judge from the bench in New South Wales during the hearing of the case, and from the bench, during the case, said to the court, that he thought the law was out of date and that sex for siblings should be now legal and that it shouldn't be illegal for men to have sex with children. And I found that despicable and despising and a complete bias displayed from the bench. I've tried in vain to get a federal judicial commission. And I think the treatment in the federal jurisdiction of children by some people in the jurisdiction of the family law court is disgusting and a disgrace, and some of those children are a tool for attorneys in representing cases. I think it's time we gave consideration to cleaning up the Act.